Are you getting ready for the SQE and wondering what evidence law is all about? Let's break it down in plain English, and quickly. The law of evidence is all about what you can show in court, how you can show it, and whether the court will even allow it. It sets the ground rules for proving your case, whether you're suing someone, defending yourself, or just trying to get a fair outcome. In civil cases in England and Wales, evidence is managed by the Civil Procedure Rules, especially Rule 32. And here's the twist. The judge plays a big role in controlling the show. They can decide what evidence is allowed, how it's presented, and even how many witnesses you get, especially expert ones. The court deals with things like witness statements, documents, expert opinions, and more. But everything has to serve one big goal: the overriding objective of justice. In other words, the process needs to be fair, efficient, and not a massive waste of time or money. Let's talk about two big ideas: relevance and weight. Relevance means, does this help prove or disprove something important in the case? And weight is about how convincing or strong that piece of evidence actually is. Even if something is relevant and technically allowed, the court might still say no, especially if it's going to waste time or ramp up costs without adding much value. Now we come to who has to prove what. That's the burden and standard of proof. Usually it's the person bringing the claim who has to prove their side. The standard they have to meet is called the balance of probabilities, basically showing that something is more likely than not. So if Gary sues Ellie for breach of contract, Gary has to prove there was a contract, what the contract said, and how Ellie broke it. But if Ellie argues that the contract was frustrated, meaning something happened that made it impossible to carry out, then she has to prove that. Sometimes the law shifts the burden. For example, under the Consumer Credit Act 1974, it's up to the lender to prove the credit agreement isn't unfair. Parties to a contract can even agree in advance on who has to prove what. Evidence can come in all shapes and sizes. Documents are huge, things like emails, contracts, or letters. These need to be shared before trial, and there are rules in Part 31 of the Civil Procedure Rules about that. Then you've got witness statements, where someone writes down what they know, signs it, and might later turn up in court to answer questions. There's also expert evidence, but this isn't just any opinion. The court has to approve it first, and the expert must be independent. Their duty is to the court, not the person who hired them. Hearsay evidence, stuff people said outside of court, is allowed in civil trials, thanks to the Civil Evidence Act 1995. But judges will always look closely at how reliable that kind of evidence really is. Opinion evidence is normally a no-go unless it comes from a court-approved expert or from someone with personal knowledge that's relevant and useful. Now let's talk ethics. Lawyers and experts have strict rules. The SRA Code of Conduct says you can't tamper with evidence, bribe witnesses, or play dirty tricks. If you do, you could face serious consequences, not just in the case, but in your career. Things can look a bit different in arbitration. That's a private way of resolving disputes outside the courts. The Arbitration Act 1996 gives tribunals a lot of freedom in how they deal with evidence, and the rules are more flexible. But even there, both sides have to be treated fairly. You might also come across the IBA Rules of Evidence, especially in international disputes. These offer a kind of global playbook for handling evidence when different legal traditions meet, like UK versus US style hearings. So that's the law of evidence in a nutshell. It's not just about throwing everything at the court and hoping something sticks. It's about knowing what counts, who needs to prove what, and how to present it in a way that's fair and efficient. If you've got that, you're already on your way to mastering one of the most important parts of English legal practice. Thank you for watching, and have a look around Dr. Yanis's channel for more on civil litigation and other forms of dispute resolution like arbitration and more informal mechanisms such as mediation.